Welcome to our channel Law for Beginners. I am Priyal. In this video, I am going to tell you about the three most top law officers of India. First, Attorney General of India. Second, Advocate General of India. And third, Solicitor General of India. So, let's get started. But before that, please do press the bell icon so that you get the future update about such topics. Now, suppose if a case is filed against Union of India or against Government of India, who is going to represent their cases? Who is going to appear in courts in behalf of these two people? So there are these officers, Attorney General of India and Advocate General of India, who represent these two people in the courts and in legal matters. So if a case is filed against Union of India, Attorney General will represent that case, and if a case is filed against state, then Advocate General will represent that case. Okay, that was a basic summarized way of telling that they are the advocates of the union and the state. Now, let's get started with our first officer, that is Attorney General of India. You all must have read about Part 5 of the Constitution, right? Which talks about the Union Executive and is from Article 58 and is from Article 52 to 78. You have always focused on president, vice president, cabinet ministers and all. But what you have missed is Article 76, which talks about the Attorney General of India. According to Article 76, Attorney General of India is the highest law officer post in India and is the chief legal advisor to the Government of India. It gives advices on all the legal matters in the country to the government. Now, it begs the question that who appoints Attorney General of India and what are the qualifications to become an Attorney General of India. So appointment, Constitution is very silent about who appoints and who removes and what is the tenure of Attorney General of India. But President of India, who is presently Mr. Ramnath Singh Kovind, appoints the Attorney General of India. President appoints the Attorney General of India. Now, what are the qualifications? There are three basic qualifications. Number one, that person should be a citizen of India. Number two, that person should be eligible to become a judge of Supreme Court. And number three, he is an eminent jurist in the eyes of the president. The first point is very clear. Let's talk about the next 2 points. For those who are not aware that what are the qualifications to become Supreme Court judge, there are two basic qualifications. Number one, the person should have experience of an advocate of 10 years in the High Court. How many years? 10 years as an advocate in High Court. Or, it is not an and, it is a or. He should have been a judge in the High Court for 5 years. If any of the qualification is fulfilled, that person is eligible to become the Supreme Court judge. Now let's talk about the eminent jurist point. If in the eyes of the president, that person has a very special knowledge of law and even if he does not have a degree of law, he can become an Attorney General of India according to the president. Right? Now let's move forward. What is the tenure? How is it removed? And what are the duties? What are the limitations and rights? Let's continue with that now. Constitution has not given the tenure of Attorney General of India. That is why our first Attorney General of India, who was Mr. Motilal Sithlawat, was appointed for 13 years. That is a very long period for a law officer to be appointed. But as he is appointed by the president, he can be removed at the pleasure of president. That means that president can remove Attorney General of India at any time he wants. Or secondly, if he wants to resign from his post, he can only resign by giving a letter of resignation to the president. Only to the president, then only he can resign. So these are the basic two things from which he can be removed. Right? Now, let's move further. What is the role of Attorney General of India? So role is he has to give advice to the Government of India on all the legal matters referred to him by the President of India. Secondly, he represents the cases of Government Union of India in all the cases. He represents the cases of Union of India in the courts. Thirdly, he gives them advice on all the legal matters if the president asks him to do so. Okay, so these were the duties. Now, let's talk about the limitations of Attorney General of India. As Attorney General of India is a very high post and is very important to the government of India, it has its own limitation. So they are, number one, he cannot, the Attorney General of India cannot prosecute any criminal proceedings without the permission of the president. That means that कि कोई भी criminal proceedings में वो किसी accused की तरफ से represent नहीं हो सकता जब तक वो president से permission ना ले ले. Number two, he cannot be appointed in any firms or in any companies without the consent of the president. कोई भी company, कोई भी firm में वो कोई भी post पे appoint नहीं हो सकता जब तक president की permission ना हो. Is that he should not hold a brief against government of India. As he is an advocate to government of India, he should not take any cases which are against the government of India. And also, you might have known that he is not debarred from doing his private practice. So he should not take case which is against government of India. This is all about limitations. Now, let's talk about certain rights which is given of this post. Number one, he has a right to sit in all courts in the territory of India. Number two, he has a right to sit in the both houses meeting of the parliament, that is Rajya Sabha and Lok Sabha, and also in the joint meeting sessions of both the houses, but he does not have a voting right. Number three, he also enjoys all the rights and privileges which are given to the member of a parliament. And number four, he can sit in the meeting of the committee of the members of parliament, but again, he does not have any voting right here also. So, this is all about the Attorney General of India. I hope you understand this post very well. Now, let's move on to our next post, Solicitor General of India. Solicitor General of India is the second highest law officer post in the India. He is subordinate to the Attorney General of India, and he himself is assisted by several additional Solicitor Generals of India. Now, basically, Constitution does not provide for anything of Solicitor General of India, not his appointment, removal, tenure, or anything by Solicitor General of India. So, it is a statutory post and not constitutional post, and its duties and functions are governed by Law Officer Act 1987. Law Officer Act 1987, and not by the Constitution. Presently, Mr. Tushar Mehta is a Solicitor General, and before this he was an additional Solicitor General of India. Now he is Solicitor General of India. The duties, functions, tenure, removal procedure is same as that of the Attorney General of India. So I am not going to repeat that again. If you want to revise those duties, functions and tenure, please pause the video, go back in the video and watch it again. Now, let's move on to our next officer. That is Advocate General of India. Advocate General of India is the highest law officer post in a state. It is highest law officer post in a state. The office of Advocate General of India is given under Article 165 of the Constitution, according to which every state has its own Advocate General. Every state has its own Advocate General. So, who appoints Advocate General? Same as the Attorney General was appointed by the head of the central, that is the President, here Advocate General is appointed by the Governor of the state with advice of the members of the Cabinet. With advice of the members of the Cabinet. This is how he is appointed. Now, what are the qualifications? There are basically two important qualifications here. Number one, he should be a citizen of India, and number two, he should be qualified to become a judge of a high court. Now, who is a person qualified to become judge of a high court is number one, he should have a judicial service of at least 10 years in any court. Judicial service of at least 10 years in any court, or he should have been an advocate in high court for 10 years. These are the two qualifications to become a judge of a high court. Then he is automatically eligible to become an Advocate General of India. This for the qualification. Now, what are the duties, functions, limitations of Advocate General of India? Let's move forward in this video now. So, duties are to advise the government on all the legal matters which is referred by the governor. If a governor asks on a legal opinion, Advocate General is obliged to give that opinion to the governor. Number second, he has to appear in the courts on behalf of the government of state, either in High Court or in Supreme Court. These are the basic two duties, and he is also obliged to give legal advices to the governor or to any person if the government refers him to do so. Okay, let's move forward. Now, what are the limitations to the Attorney General? What are the limitations to the Advocate General of India? Number one, he should not hold a brief or anything against the government of state. It is same as Attorney General. It's just that this is the governor and that was the president, right? Number second, he should not prosecute any accused person in any criminal proceedings without the permission of the governor. Number third, he should not take the post or director in any company or in corporate without the permission of the governor. These are the basic three limitations placed on the Advocate General of this state to avoid the conflict between the government and himself. As again, he is not debarred from doing his personal practice, right? Now let's talk about the rights of the Advocate General. Number one, he has a right to attend the House proceedings and right to speak in the proceedings but has no right to vote. Number two, he has right to be heard in all the courts. Number three, he has privileges of all the members of a house. He has privileges as members of house. Now, I might have forget to mention one thing, the removal procedure of the Advocate General. So basically, as he is appointed at the pleasure of the governor, only governor can remove him from his post, or either he can resign himself from his post by giving a letter of resignation only to the governor. But basically it is seen that if a government is replaced or if a government is dissolved, automatically the governor gets replaced or automatically the Advocate General gets replaced or he automatically resigns. I hope you understand all the officers very well. Thank you for watching our video, and if you like it, please do subscribe to our channel and please do let us know if you want to be explained anything else about the same video or any other topic. We would be happy to explain. Thank you.